The matter that we brought was to seeking redress under Article 146 of the Constitution. And primarily, it speaks of freedom of expression. Freedom of expression is not just speaking out, but is the receiving of information. What is critical and essential to a free, fair, democratic electoral process is the essence of receiving information from all of those political parties that are going to be participating in the elections. Mm-hmm. They must have unfeathered, uncastrated access to all mediums to provide the information. But what we observed during the electoral process in of itself, because the matter we brought was an elections process, proceedings precision, which is novel in of itself, that can only be brought during the electoral process, questioning the actions of GCOM under Article 146. GCOM, being a public administrative agency, is required to, when Parliament is prorogued, there's some the will of the people goes to them through the Representation of the People's Act for them to conduct the elections in a very independent of the political system. We brought this action saying that GCOM is not doing his job. This is the interlocutory aspect of the proceedings that we brought. And we would like the court, we never said to stop. The Constitution says that for an elections to stop, it is the Guyana Elections Commission and the leader of the opposition who must get together and decide whether the elections should proceed, whether it's part of the elections, the whole elections, or not. The court doesn't have the authority to stop an election. But what was advocated by the political system, they sort of send this thing through. But I would concede.
System, Dr. Thomas,
I would concede this.
Say that the court doesn't have the authority to bring an electoral process to an end?
The court does not have the authority or the power under the Constitution. And if you go on to read Article 163, et cetera, it is the Elections Commission and the leader of the opposition that must get together and decide on whether the elections should be stopped or not.
Elections Commission.
It is not. So the action was brought asking the court to issue a prerogative writ or a mandamus, which they can do to order GCOM.
Okay.
This is what we saw, to order GCOM to uphold their responsibility. Now, you have spoken, Senior Counsel, about the colonial times and history. The Guyana Constitution, Article 62, in conjunction with Article 161 and 162, it addresses what is called an elections petition. The Constitution also addresses, there are four methods by which you can bring a constitutional action. One is for criminal violation, one is challenging a seat in Parliament, one is what is traditionally known in Guyana as an elections petition, which technically should be a post-election petition. And then the other one which we brought is an election process proceeding petition, which speaks to the electoral process in of itself. Now, the Constitution does not provide for an elections process proceedings petition. It provides for a post-elections or a petition. In the Chief Justice inter partes process in chamber ruling, he refers to Article 62 in conjunction with Article 162. And he used this case, Peachtree, Gladys Peachtree.
Yeah, I was coming to that.
Gladys Peachtree,
Yes.
which is where you spoke about reserved powers to the crown. Mm-hmm. So archaic in of itself, right? We argued that you cannot apply Gladys Peachtree to an elections process proceedings petition. Because in this present day, we have no crown. The 1980 Constitution took in that Gladys Peachtree as a basis, because the president at the time, or the prime minister at the time, wanted to have those same reserve powers, that nobody must interfere with the elections as it was going on.
Wasn't it the Gladys Petrie case that was tried by former Chief Justice Bollers?
Yes, indeed.
No, yes.
Yes,
And
indeed.
what he said was, you cannot, in effect, you can't stop the election, but you can challenge the result on an election petition.
Afterwards.
Yeah, afterwards.
The post-elections
Yeah,
petition,
that
and that
was his decision. Yes.
absolutely.
In other words, what you were saying, you really can't stop an election. The election must be held, but then you can challenge the result by way of an election petition. That is the decision in Gladys Petrie.
Absolutely. We never brought a Gladys Peachtree type action. And the reason why we never brought a Gladys Peachtree type action is because we wanted to have redress on the process as it was unfolding at the time, because we felt that it was important that every single participant in the electoral process must have an opportunity to present their policies and the principles, so that we, the citizens, civil society, can analyze it in a timely manner, so that we can make these critically informed consent decisions that affect our fundamental and civil rights, political,
As we-
economic,
yes, but
at the time of polling.
You were doing that before Election Day, and you have what was before the court described as the election process petition. You were
Petition. Yeah.
convinced that GCOM was not doing their jobs in terms of people receiving from all the television stations and the newspapers and Linden and so on information to have them make informed choices at the elections, and that in itself, you said in your petition, was really wrong, and this election really shouldn't proceed. You say you weren't going to, you didn't want to stop the elections, but you wanted the court to tell GCOM something. What was that?
We wanted
do
the
its
court
work.
to order GCOM to examine the situation as we were complaining of it, and to bring some resolve or to correct the situation
Before Election Day.
before election day.
I see. I see.
Before election day. And the court had a right, even if it's the last hour or minute before the election, to hear our petition and to decide on that specific issue. Now, we took this matter through the process of going through the full court of the High Court. They said they had no jurisdiction. We pointed out to them that the Judicial Review Act, which has been assented by the President but has not been enforced, right, was a jurisdictional base by which they could have answered or addressed the question. We also pointed out that because GCOM is a public administrative agency, that there was jurisdiction there. Mind you, the court, the chancellor had issued practice directives just prior to the elections that all constitutional questions go to him. Article 152 give us, because of the contravention of our fundamental rights, they give us what is called as of right to a hearing for this. Even that in of itself was violated. We addressed the matter before the Court of Appeals. We decided, because so many councils here are so wired into the political process, we went into and we hired senior counsel such as Stanley Marcus under the advice of Justice Messiah and to the dogged advice of Senior Counsel Bryn Pollard. We went to the Caribbean Court of Justice just a few weeks ago. The ruling of the Caribbean Court of Justice, they refused the special leave, and they also said this. They said that the Guyana court here have not addressed. They said the issue is substantive, it's interesting. You were there, you heard for themselves,
Yeah.
and they must hear the issue. They must hear it. We intend to, together with all of the other substantive, non-interlocutory matters, to bring those matters before the court again.
Well, if it pleases this court here, I think this is a good time to end this first program for 2013. We've been given the signal. Yes, we can go on, but I think this kind of discussion, it might have seemed listeners to be exhaustive and quite comprehensive, but it is not so. There are many other questions that we have not asked, but you get the idea, I'm sure, about the exploring, to put it simply, of the constitutional issues that the man in the street doesn't really care for, but we know that by the time we would have finished things constitutional and electoral, this public must know, and I'm hoping to get this into schools too, if even through a back door. But the point is, I want to thank Dr. Thomas and Senior Counsel Pollard. We have not gone into your litigation in front of the Caribbean Court of Appeal. We've just summarized what is the state of play now. I promise on program number 2 for 2013, we'll go into the litigation engaged in by the GNCPP, and then the scope of the GNCPP in terms of its personnel. We'll surprise you with some of our membership and so on. And I will have to keep answering the question when Dr. Thomas looks after what he calls his global responsibilities as to whether we will be here. Yes, we'll be here even when he's not here in person, in the presence of some very eminent representatives of the GNCPP. I was burning to ask you, I suppose we'll keep it for next time. Do we have a minute or two? No, we don't. You had a final, your very last letter, Senior Counsel, you were very puzzled. You said it's puzzling that the Commission of Inquiry did not rely on Commonwealth precedents as they affect ministerial responsibility. And I have your letter here and so on, but I suppose we can keep that for another time, because there should be another time.
Senior Counsel Pollard, would you like to make, as you have written in there, just a final comment in relation to the Commission of Inquiry, in relation to the letter that you have written, and we're in. Leave that in. Yes, indeed. Yes, indeed.
Yeah.
And I must say thank you, Mr. Alan Fenty, and must say thank you also, Senior Counsel Pollard. It has been quite an appetizing, interesting, and formidable discussion, and also to have you here. As I've said to you, that there's no amount of words or money that one can pay for the experience that you come to bear with regards to these issues.
Yes, the time is. Now, don't let's tell them who, Dr. Thomas, don't let's tell them who, but on our next program, Senior Counsel Pollard will be joined, as if he needs any support, but no, he'll be joined by another legal luminary, and we leave that for program 2, 2013. Thanks you all for listening. Get into your constitution, ask your representatives to so do. This was the GNCPP and you, a forum for civil society.